Hey, it's Chris with a video on beneficiary planning. You may have seen the terms out there, Pro Rata and Per Stirpes, or maybe you haven't. But these are potentially important terms if you have beneficiary designations on any of your investment accounts. So let's run some disclaimers and then we'll get into things. All right, welcome back. So, first let me kind of set the scene here for what type of accounts have beneficiaries, and more than likely you're aware of this. Actually, there's some terms here, some parlance that you may not be aware of. So let's get those guys off the screen. So we have in the investment world, we have non-IRAs and we have IRAs. All right. And in fact, the term beneficiary, at least here at my firm, really only applies. We use the term beneficiary when we talk about IRAs, and we use the term transfer on death when we talk about non-IRAs. So sort of in my vanilla investment world here, we have IRAs and non-IRAs. And then actually, annuities will fall under IRAs for this because annuities have beneficiaries, not transfer on death, and they could be IRAs or not IRAs. So, but we have non-IRAs and we have IRAs. IRAs, Roth IRAs, 401ks, annuities all have beneficiaries. Now, these are the investment accounts that have stocks, bonds, mutual funds, your basic vanilla stuff. Then there's non-IRAs. What's a non-IRA? Well, it's an account that's not an IRA. Kind of silly, but that's the truth. And we call these TODs, or transfer on death. And these are your accounts, your investment accounts, again, vanilla stuff, stocks, bonds, mutual funds. And I do see these TODs applied at banks as well, with checking accounts, savings accounts, and other bank accounts. So again, beneficiaries and transfer on death, they essentially make the same thing happen. They transfer monies to loved ones when you pass away. But again, just a technicality, transfer on death applies to non-IRAs, and beneficiary applies to IRAs. So now that we've distinguished that, let's get into some kind of straightforward cases, and then life throws us curves. I'll kind of just give you some moments when this beneficiary planning and reviewing what you've done might be pretty important. So let me switch the screen here. All right, and I'm back. So let me show you what I brought up and what I'm looking at. So let's just say a straightforward case. We have you and your spouse, and you have two kids. And your beneficiaries are written such that if you pass away, your spouse gets all your money. If your spouse passes away, you get all of their money. And then upon second death or simultaneous death, your kids get your money. If there's one kid, this pro rata per stirpes won't be so impactful. But when there's two, I'll show you why this is, when it becomes impactful. So traditional beneficiary planning, of course, call it you and your spouse, husband, wife. You guys get each other's money, and then upon second death, your kids split your money. Straightforward. And in this moment, pro rata and per stirpes don't matter. However, you grow up, and now you have grandkids. And this is when things can get interesting because now the designation of pro rata and per stirpes, now it matters if one of your kids predeceases you. So let me define pro rata and per stirpes. Let's get onto that page here real quick. So I found this on a website, trustandwill.com. I knew the definition. Their definition works for this case, so let's give them some credit for having the definition posted there. So I do a lot of fact checking. If you see something on the internet, I mean, if I know it's right, it's fine. But if you're not sure, you have to fact check some more. But I know these definitions to be right, and at least I can credit them for doing this. I have no idea who they are, by the way. So let's just read this together. In the case of pro rata, because again, there's pro rata and there's per stirpes. The inheritance is divided up equally amongst your primary beneficiaries, right? Equally amongst your primary. If one of them were to pass away, the deceased beneficiary's share of the inheritance is redistributed equally amongst the surviving beneficiaries. That means that their inheritance could potentially increase. Okay, so let's just look at pro rata then. Let me apply that to my case. So your primary beneficiaries share your money equally. However, if one beneficiary predeceases you, the other one then gets everything. Do you see the potential issue? So if you have two kids and one passes away with pro rata beneficiary designations, child 2 would receive all the money. These grandkids would not receive any inheritance. This grandkid would then receive all of your funds. So what do we do? Well, clearly, you can always redo, if you have enough time, you redo beneficiaries. But another way to kind of mitigate that risk is it's called Per Stirpes, right? So now, Per Stirpes, if one of your beneficiaries predeceases you with a Per Stirpes distribution clause, then their share of the inheritance would pass directly to their children or other direct descendants. Let's just go with kids here. Any other primary beneficiaries would only inherit their original intended share of the property. So let's go back to this and let's mark this up for what this means. So pro rata means that, again, pro rata, this child is unfortunately passed. Child 2 gets all the money, and grandkid 3 then gets, all the money. If you have a Per Stirpes arrangement, and now your Per Stirpes, if child 1 passes away, the grandkids still receive child 1's share of your funds. So these two, if it's a 50-50 breakup here, which it normally is, now each grandkid gets 25, these two each get 25%, and this one gets 50%. Now maybe that actually, as I mark that up, that may not seem fair. You want all grandkids to get monies equally. But there's, at least in a Per Stirpes arrangement, your first child, their kids do receive some funds if you don't get a chance to redo your documents. First kid's spouse, at least some money is going to that leg of the family until you can redraw the documents. Now, given enough time, child 1 passes away, maybe grandkid 1, grandkid 2 get 33%, child 2 gets 34%. You just have to round it up to 100. These can then become primary beneficiaries, and then those two, actually going further with this, those could then be pro rata, meaning if grandkid 1 passes, grandkid 2 gets all of that half, right? But this is just going. You can get crazy with this, right? You see how this can get a little bit. I don't want to manipulate this for the sake of the video here, but I think you can understand at least the difference between pro rata and Per Stirpes and how to mitigate that risk by putting a Per Stirpes designation on all or some of your accounts, whatever you might determine necessary. Now, I'm going to throw you a little bit of a twist here. I think you see how that works, and I don't see people get tripped up too much on that one, but I'll show you where I do see people tend to get tripped up. Now, let's say it's you have your kids, but now there's no spouse here, as you notice. Your spouse, you're either divorced or your spouse has passed away. And so now you have your kids as primary beneficiaries, and we go back to that same whole pro rata per stirpes conversation we just had. But the wrinkle is, you know, uh, boom, you get remarried. Look at that, huh? So you're here with your beneficiary designations, and your spouse is here with their beneficiary designations. And it doesn't matter, 2 kids, 3 kids, 4 kids, the planning all unfolds the same. But upon this remarriage, you might say to each other, look, I've got my estate plan in place. You might say, look, I've got my estate plan in place. I'm good. You've got your estate plan in place. You're good. You may have pro rata per stirpes. Your second spouse may have pro rata. It doesn't matter. Okay, so it could be a non-issue upon a second marriage. But where I see this become an issue is when somebody, either spouse, has no beneficiary designations or no estate plan. Because for most states, the beneficiary plan is the default option is your spouse. If your spouse passes intestate, that means with no will or no beneficiary designations or whatnot, and money goes to their surviving spouse, almost like by default. And so now you can see, if you go with me here, if you're remarried and you don't have a plan, now all your money goes to your spouse, and then it gets doled out amongst your spouse's children, and yours miss out. It could go vice versa as well, just to draw it the other way. Say your spouse passes and they had no plan. All their money comes to you. Now you've got to find a way to dole it back out to their kids, if that's the way you want to do it, which I would presume, right? But you have to be careful, because spouses are the default inheritors of assets unless you stipulate otherwise. And so, it could become a problem upon a remarriage, just to bring to your attention, right? And then there's one more case here. All right, so the last case is on the screen, and this is sort of kind of goes back to the first chart when you were married, second to pass. This is the schematic again. Yeah, this just goes back to the first case. Now you find yourself single because your spouse has passed. You do not remarry. Again, you have a decision to make here. You have a choice for pro rata per stirpes. And again, it's if you want funds to kind of stay within a certain child's family, then it's a per stirpes designation. But, perhaps you don't want monies to stay with one particular kid's family. This is your business. I can't say why, but then you can do pro rata, such that upon first passing, the surviving primary beneficiary receives extra funds, the deceased child's half. So, it's just kind of, it's just interesting stuff to know and things to be aware of. And I have had some cases whereby in older clients' adult children, health was failing. And on a pro rata level, the sick adult child, at a pro rata level, their kids would receive nothing if they passed away, and then the parent, the grandparent really, the grandparent didn't get around to redoing their documents, which unfortunately there's 2 bad health concerns here for this case I'm thinking of. So, I can't say that this will come into play too many times, but I do think it's important to be aware that when you name beneficiaries on an account, you can name beneficiaries pro rata or per stirpes, and their significance to the and potential significance to the outcomes. So hopefully you found this helpful, and best wishes in your designations.